You can start now, sir.
Okay, all right, fantastic.
We are live.
Fantastic. Thank you very much, John. The President of the National Industrial Court of Nigeria, the Honorable Justice B.B. Kanye, PhD, the Honorable Judges of the National Industrial Court of Nigeria, and other judges present. It gives me pleasure to welcome everyone to yet another round of knowledge sharing sessions that ELAN, that is the Employment and Labor Law Association of Nigeria, has put together to interrogate a decision, an all-important decision touching on the jurisdiction of, again, two courts who now appear set against each other to resolving the exactitude, the extent or limit of the jurisdiction of each other in relation to maritime labor claims. That sounds a new one. If I could just give additional context, maritime labor claims, we all know that by the community of a number of statutes and the Constitution, particularly the Administrative Jurisdiction Act, Merchant Shipping Act, and the express wording, Section 251 of the Constitution of the Federal Republic of Nigeria. Maritime claims are vetted in the Federal High Court. Now, 254, third alteration to the Constitution of Nigeria, has gone further to say, notwithstanding the provision of 51 and a number of sections within the Constitution, employment and labor-related claims are solely and exclusively vested on the National Industrial Court of Nigeria. Before now, and then had gone on to itemize a number of subsections, 251A, 251CA, and 251K, to suggest clearly that maritime labor-related claims arising from maritime or that can ordinarily form an aspect of maritime claim should be exclusively or will be looked at the National Industrial Court. In the course of 2-3 years, a number of decisions issued at the Federal High Court, where, as you can imagine, in maritime claims of this nature, to secure the enforcement of such maritime claims, usually practitioners go for a preemptive remedy of seeking to arrest a ship, which are roving objects anyway. And one or two of the decisions have suggested that, yes, underneath the whole claim is the need to secure the wages of seamen, hobby members, and all. But that, to the extent that there's an aspect of labor we fight for, the Constitution says should be industrial court, the Federal High Court would no longer be able to exercise jurisdiction on such matters. Empty and purpose was a decision made by Justice Faji, Federal High Court last year, which I found jurisdiction of the Federal High Court that, irrespective of the wording or the proposition being put forward by, thankfully, one of concerned today, that it should still continue to be at the Federal High Court. The matter has gone on appeal, and this month, the Court of Appeal agreed with the appeal, agreed with the argument put forward by Appellate, represented by Dr. Lanipe, that indeed matters would now be said or should be looked at only at the National Industrial Court. I mean, there's quite a number of criticism here and there, critique here and there, and we just thought that we should have a back and look at what this is all about. Before I proceed, and thankfully we have a rich array of speakers, discussants, and case reviewers to look into this and examine all the angles and contours and whatever it is that could come out that decision or the intendment of the the draftsman in seeming to have put the jurisdiction on the industrial court. Before I go on, allow me to invite the president of the court, now industrial court, the very cerebral Honorable John Kanye, to kindly give us his opening remarks. And I'm sure my Lord would set the ball rolling. I have no doubt of what this is all about. Maybe that was why I took my time to just briefly analyze and see I'm part of the people discussing this order. You have the floor. Thank you so much, my Lord, for joining us.
Thank you, Mr. Folabi Kuti. I don't know whether I'm heard clearly.
Yes, my lord.
We can hear you, my lord.
Okay. I understand some of my colleagues are also part of this webinar.
Yes, sir.
I also understand there are a number of senior advocates and members of the outer bar. So I welcome everybody and thank the organizers for deeming it fit to organize this webinar in respect of a decision such as the one under discussion. Let me start by explaining one or two things. Justice Faji is a very good friend. He's more of a brother, really, than a friend. When he decided the case at his level, he actually sent a copy to me. And I read through the judgment and then called him on phone and then told him my reservations about the premises upon which he based his decision. I'll give you just one. For instance, he relied on Section 91 of the Labor Act, which defined worker to exclude those who are on board vessels and things like that, and then ruled that because of that exemption, the intendment is not to confer jurisdiction on the National Industrial Court. I drew his attention to the fact that the Labor Act is first and foremost a labor standard setting act, and that could not in any way justify it being used as a determinant for jurisdiction. So when the Labor Act says labor standards should apply to workers, but not workers on board ships, that is not tantamount to saying jurisdiction had been divested from whoever has jurisdiction over labor. There were other issues I drew his attention to, but of course, the matter went to Court of Appeal and we have it as it is today. Secondly, I also posted the same judgment of Faji J to the WhatsApp group of the judges of the National Industrial Court. And quite some lengthy discussions ensued. The one that is particularly lengthy and interesting is the one by my colleague, Honorable Justice Arowo Shebe. In fact, it's so long, it's just that time will not allow. I would have loved to read exactly his comments in respect of the judgment, but it's so long. But what I did was I forwarded the comments to Justice Faji, just so that he can follow the line of discussion. In summary, the general thinking was that the decision to divest NIC of jurisdiction in respect of wages of workers in the maritime sector was not a proper construction of the 1999 Constitution in terms of Section 254C1. Of course, the matter has gone to Court of Appeal. Court of Appeal has held that a literal interpretation of Section 254C1 cannot justify taking away jurisdiction in respect of those matters, particularly when you read the opening words, notwithstanding Section 251, 257, and any other provision of the Constitution. Now, there's something I need to point out, and I think it goes to, in a good deal, to how we interpret or look at. First, there's this myth about the NIC having taken all the jurisdiction of every court on earth and given it to itself. Just look at section 254C1. There's nothing other than labor and employment in that. No matter what happens, it's within that. Secondly, within the structure of the exclusive legislative list, all the items in the exclusive legislative list are almost the items given to the Federal High Court in terms of its jurisdiction, except, of course, item 34. Item 34 deals with labor, minimum wage, industrial arbitration, and, and the like. None of those mentioned items in item 34 is given to Federal High Court. And my view has always been that if the National Assembly reserves the right to determine which court should hear and determine matters in respect of the exclusive legislative list in terms of a federal court, it should also have the right to determine which federal court, so to speak, should have and determine matters coming squarely within the items provided in item 34, particularly in respect of the exclusive legislative list. Now, once we understand that as the background, we can begin to understand why the NIC is a specialized court and why it is specialized and restricted to labor and employment. In fact, nothing else. Even when the words incidental or matters relating to are used, they must be understood as matters relating to the workplace or matters that are incidental to the workplace. And there is something the National Assembly did, and people don't seem to really give it a second thought. I've always asked lawyers, I've always asked people, even in papers I've written, I've made the point that go back and take a look at section 254C1. If you can do a little bit of counting, the word any is used about 42 times in defining the jurisdiction of the National Industrial Court. Now, no legislature, no draftsman uses words carelessly. It cannot be that any is used 42 times in respect of labor and employment if the idea is not that everything about labor and employment should simply come to this court. These are things that we really don't sit down and give second thought. And of course, for me, it's because we have not done that we have other instances of a restrictive jurisdiction. I'll give you an example or two. There is a Court of Appeal decision, I can't remember the name right away, but it's something I can always forward, which dealt with vicarious liability. Yet, there is a statement within that decision by the Court of Appeal that says the jurisdiction of NIC in any of the items listed in section 254C1 will only arise if there is an employment relationship. And I felt that for me, such a statement is too general. And I'll give you a simple example. Take jurisdiction of NIC over strike. Students of labor law know that there are different kinds of strike. We have what is called sympathy strike. We have secondary strike. And what is that? ASU may be doing a strike against its employer, a university. You could have a union like medical and health workers who feel for ASU, sympathizing with them and also joining in the strike. Now, as between the employer of ASU and this medical union, there's no employment relationship whatsoever. So if we go by this Court of Appeal decision, what it means is that because there's no employment relationship, the factor of a secondary strike cannot be litigated in NIC because there is no employment relationship. That is one. There's another Court of Appeal decision which said, once there is no dispute as to the quantum of wages that is being claimed by an employee. In other words, if they are agreed on the figure and the issue is simply that the employer did not pay and the employee wants it paid, this Court of Appeal decision says that that is not something for NIC's jurisdiction because the dispute does not exist. Since there is no dispute as to the quantum, then automatically what the suit is about is a claim for death. And consequently, because it is a claim for death, it cannot come to the National Industrial Court. Now, I give these examples to just show the attempt at a constricted jurisdiction of the NIC, even when literally, in terms of the wordings used, the legislature had never wanted it to be in doubt that jurisdiction over employment and labor, in fact, all employment and labor matters should reside with the National Industrial Court. Of course,
That's correct.
there is advantage in the matter coming. Again, I'll tell you a little, sorry for taking your time. I'll tell you a little story. Again, it involves Justice Faja and myself. When he was in Ilorin, there was a case that was filed before him by a nurse who was working with University of Ilorin Teaching Hospital. Of course, by the time the third alteration came, he was compelled to transfer the matter to National Industrial Court, and I was asked to handle the matter. Now, the matter dealt with this lady complaining that she'd been unfairly suspended and that because her promotion was also denied. And what was the problem? Her father had fallen sick, was hospitalized at the University of Ilorin Teaching Hospital. And then, I think 3 months or so, according to their claim, based on wrong diagnosis, the father died. So the family of this lady decided to sue University of Ilorin in the thought of negligence. Of course, they went to the Federal High Court, and it was Justice Fadi who heard it. But this lady went for the death certificate of the father. And when the death certificate was issued, the death certificate had the cause of death wrongly put. Instead of returning the death certificate, what she did was to simply hand it over to her brother, who was actually pursuing the negligence matter in the Federal High Court. And University of Ilorin Teaching Hospital got angry and said, look, as our staff, we are supposed to have brought back this death certificate in case there is an error. Instead, you send it to your family. Because of that, we are going to suspend you, and the promotion that you are due for, we are not going to consider you. So she now sued again in the Federal High Court. It was that suit that was then transferred, and I handled it. Of course, none of the parties cited it, but I came across a Court of Appeal decision that says promotion is not a right, it's a privilege. But the issue here was this. Here is a lady who is being denied promotion, who is suspended because she decided to give a faulty death certificate to her parents to pursue in a court of law. In other words, for going to court, she's being penalized. And I asked myself, on a policy ground, if not on matters of rights, should a court of law promote this kind of thing? If I'm to apply uncritically the Court of Appeal decision that says promotion is not as of right, I could easily conclude there and then that, look, she does not have a case in terms of the promotion. And so hold that there is no case and simply strike or dismiss it out. But I went through some Indian literature where they said, yes, in matters like this, it's often nice for the courts to respect the internal management arrangements of companies. But that once it can be proved that a company acts mala fide or vindictively, then a court of law is mandated to pierce that veil and go into it. So what I did was, I now qualified. I said, okay, yes, the Court of Appeal said promotion is not a right. It's a privilege. But where this denial is vindictive or in bad faith, then I think a right inures for which litigation can ensue. And I held that. As soon as I decided the matter, of course, I sent a copy to Justice Faji. And he confessed to me and said, look, now I understand why there is the necessity for a specialized court. If I were the one doing this case, don't forget, he could easily have been the one, but for the fact that the third alteration came. He said, I would have stopped at the Court of Appeal decision that promotion is not a right, it's a privilege, and ended the matter there. He said, but because as a specialized court, I had the inkling to go beyond that, I had been able to now see through certain acts and so on. Why am I bringing this up? It is not for nothing that the National Assembly deemed it fit that we should have a specialized court in labor. In fact, if you follow the trajectory at the ILO, that's International Labor Organization, it's always been a support base that individual member states must have an adjudicatory system for labor disputes separate and distinct from what is conventional. And it's not done idly, it's done on purpose, because there are certain basic things within the context of labor that can be understood only by judges who are knowledgeable about workplace nuances and so on. And in the recent decision by Justice Ogaku, as I think in one decision decided in December, I can't get the name exactly, he made reference to even the House of Lords in England deferring to employment judges when it comes to issues of the workplace, because there are certain basic things that are commonplace and understood. And it is because of the specialized nature of this court that these matters are done. So when it comes to the issue of jurisdiction, the point I want to make, and the point I want as a takeaway, is that it is not for nothing that the National Assembly used the word any in defining the jurisdiction of NIC about 42 times in section 254C1. The intention is that everything about labor, everything about employment, in fact, everything, if possible, about the workplace should go to the National Industrial Court. Of course, there are always what you call borderline cases. I've had cause, for instance, to ask counsel in open court. Yes, the fact that certain things happen in the workplace does not necessarily mean jurisdiction inures. And I give the example of murder. If a worker carries a gun and shoots another worker in the workplace, will you file for murder in the National Industrial Court? The answer almost automatically is no. So we understand some of these basic issues, and as much as possible, even within the structure of the NIC, we've tried as much as possible to keep within. There are other areas, so many, not necessarily within the maritime sector, where even jurisdiction is confused. And one area which I will quickly mention is this area involving the teachers. We have what is now called the Conference of Secondary School Tutors. They are a body registered under Part C of the Companies and Allied Matters Act. They've gone to court asking that they be allowed to take check-off dues. And they've gotten judgment as high level as the Court of Appeal. But it raises fundamental questions. For instance, check-off dues is an incidence of trade unionism. And the Trade Unions Act is very clear that Companies and Allied Matters Act does not apply to it. And then in section 1 or 2, I can't remember exactly now, it's very specific. A body that is not registered as a trade union, if it does that which only trade unions can do, it has committed a crime. Now, if as a registered body under Part C of the Companies and Allied Matters Act, you go asking for check-off dues, that which is only an incident known to trade unionism, have you not committed a crime? So sometimes there's a necessity to have a broader view on some of the things we do. Then and only then can we be able to appreciate why the legislature thinks it worthwhile that specialization should be kept within the NIC and restricted to all matters involving labor, employment, or the workplace. Thank you.
Well, my Lord, resisted it. Of actually wasn't in at some point that my Lord did remarks having the review now. That's all right. When I'm sure my Lord said the ball rolling. Thank my Lord for cerebral. Within 5-10 minutes, no more, that actually covered the field was further from the Lord has left. Thank you again, my Lord. But just before we quickly turn to the next, there are a couple of things my Lord highlighted, which I was thinking of as my Lord made those opening remarks. Yes, it is correct. And drawing from the critique Justice Amerjeet, which I was opportune to read then, made of Justice Faji's judgment, he looked at it, not I looked at it from the use of any, that it confers absolucy on the industrial code on all employment and labor matters. And to that extent, that, I mean, the literal interpretation has made it very clear, so there's no need to on to any other thing. And if we take it from that, my Lord just gave the analogy. If a worker kills another worker, or there's more in the workplace, the industrial courts be the courts to come to, where has also come to, if the decision that we're about to view is anything to buy, I might be in the affirmative, my Lord. My Lord, as you will not express any jurisdiction. As my Lord spoke, I have a look at 254C sub 5, and it was so clear. The purpose of exercising any jurisdiction the court has been conferred with, the court would also be able to exercise jurisdiction on criminal causes and matters arising from matters with the court that have been conferred jurisdiction in 254. It's all legal fiction following what is the literal interpretation which is given here, and then which we think there's perhaps need to look beyond the settled intent of the general scenario that plays out. For example, it is maritime, and we are saying that, okay, maritime, you almost immediately want to file for a permit because some vessels are objects, as is described. So you want to secure and apply to arrest the ship. Now, that creates a problem, which the discussor would have an opportunity to look at. That we can come to the industrial court to seek to arrest the ship. My Lord, again, we thank you for that.
On that, I was discussing with a colleague, Justice Obonya. He drew my attention to the rules of procedure of the National Industrial Court regarding arrest of property that may be useful in securing the outcome of a particular case and so on. His argument is that there are enough provisions within the structure of the rules to cater for such a fear as to, because NIC does not have the power to arrest a ship, that is within the structure of the maritime law itself, it may be handicapped if an employee comes to NIC to claim for wages in respect of a maritime claim and things like that. But these are matters that, for me, on a case-by-case basis, will be determined in terms of the structure of rights and so on.
Yes. We thank my Lord for the opening remarks. Without much ado, I would like to call Mr. Nonso Azi, but just before that, I think it's important to emphasize that it has been put together by the Employment and Labor Lawyers Association of Nigeria, ELAN. ELAN is a group of Nigerian lawyers, professionals with special interest in labor and employment matters. Session progress. Have in the chat box information related to ELAN and what it does, to be a member, every other thing, the website and all of that. You'll be able to get full information there. Mr. Azi, please, it's time to have you. And before that, I think it's important to just say one or two things. Nonso Azi has a solid professional background built on strong work ethics and integrity, having worked at top specialist and full law firms in Lagos. He's currently a member of the Maritime Practice Reform Committee. He's recognized as a generation lawyer in shipping by Good 500. He's been on top tier law firms He's gone in-house, worked at APM terminals. It's just been over in maritime and shipping. And I recall that when the decision came, I think it was one of those who actually posted it on Ellen's WhatsApp. And of course, with a strong position, which I will leave for him to come to when it's time to not do the review, when it's time to make a reply on which will come to after the case review. Please not have the floor, please. Please go ahead and give us the case review.
Okay. My Lord Justice Kanyib, my other Lord Justices who are present, the learned Sikhs, and ladies and gentlemen, it's an honor to be the case reviewer on this all-important case. It's indeed groundbreaking and controversial. And without much ado, this is a Court of Appeal decision handed down by the Court of Appeal Lagos Division on the 5th of March, 2021. The case was between the vessel MT Sun Purpose, formerly ex-MT Tapti, and the owners of the MT Sun Purpose, and Amerjeet, Singh, Bains, and 6 others. So as it were, the plaintiff at the Federal High Court were crewmen, or if you like, seamen, who had worked on the appellant vessel, the vessel in question, the rest. These crewmen felt that they were being owed wages for the services they had rendered, in favor of the vessel. So they approached the Federal High Court to have the vessel arrested. So they obtained an order of arrest, pursuant to the Admiralty Jurisdiction Act and the Admiralty Jurisdiction Procedure Rules, which lays out the substantive and procedural, process of effecting an in rem claim. Essentially, they obtained an order of arrest, and the appellants, who were defendants at the Federal High Court, entered a conditional appearance and raised an objection to the court's jurisdiction to entertain the matter. Remember, the vessel had been arrested by the order of court. So the application to discharge the order of arrest was refused by the lower court. Subsequent upon that, the defendant appellant now appealed to the Court of Appeal. It is interesting to know that the Federal High Court granted the order of arrest, and the defendant appellant subsequently entered the conditional appearance, as I've said. So Justice Faji of the Federal High Court anchored his decision to lift the order of arrest on Section 91 of the Labor Act, which, as we all know, defines a worker as any person who has entered into or works under a contract with an employer, but does not include any person employed in a vessel or aircraft to which the laws regulating merchant shipping or civil aviation applies. So the Federal High Court, per Justice Faji, went on to say that as Section 254C of the Constitution incorporates aspects of the Labor Act, when you look at the sub-rules, the sub-provisions of Section 254C, there's a reference, there's an allusion to Labor Act. The lower court was of the view that the act is part or forms part and parcel of the said section and must be considered altogether. Specifically, that is Section 254C sub B. The court therefore held that the Labor Act has defined the extent of the NIC jurisdiction by excluding crew members, or if you like, seamen, covered under the Merchant Shipping Act, and that the subject matter of the claim was outside the court's jurisdiction. The court then ruled that the matter fell under the Federal High Court jurisdiction and indeed dismissed the defendant's appellant application. Dissatisfied with the ruling of the Federal High Court, the defendant's appellant appealed to the Court of Appeal. That was by notice of appeal dated 28 May of 2020. So in their brief of argument, the defendant's applicant canvassed 6 issues for determination. The first 2 issues are germane to our topic of discussion, and I will read. The first issue that was framed before the Court of Appeal was having regard to the relevant provisions of Section 254C, sub 1 of the 1999 Constitution of the Federal Republic of Nigeria, as amended, when considered against the backdrop of the respondent's claim, as endorsed on their statement of claim, whether the trial court was not in grave error in dismissing the appellant's application dated 29 June 2018 and assuming jurisdiction over the respondent's claim. Number two, whether the trial court was not in grave error in applying Section 91 of the Labour Act to assume jurisdiction over the respondent's claim without considering and applying the provisions of Section 254C, sub 1 of the 1999 Constitution. On the respondent's part, Mrs. Madu, who settled the brief, raised only two issues for determination, one of which was one, whether the respondent's cause of action commenced as an in rem action as provided under Section 251G, which gives the Federal High Court exclusive, as it were, jurisdiction over maritime claims or matters of the 1999 Constitution as amended, and section, specifically Section sub R and Section 3 of the Admiralty Jurisdiction Act, which is predicated on a general maritime lien, falls under the jurisdiction of the National Industrial Court. For emphasis, it is important to note that if you look at the Admiralty Jurisdiction Act, which was a decree originally made in 1991 under Babangida regime, following international convention on arrest of seagoing vessels, because which Nigeria adopted and now localized it by in the form of AJ, which is the substantive act, and then the AJPR. You will understand that maritime claims are divided into two: general maritime claim and proprietary maritime claim. So it is important to note that the defendant, the respondent claimant, had anchored their claim on what is specifically a maritime claim, which gives rise to a right of arrest. But we can come to that maybe when we come to review. So learned counsel for the appellant, Dr. Lani Bekunye, argued on behalf of the appellant that for the Federal High Court to assume jurisdiction in any action before it, the subject matter must be within the ones envisaged and contemplated by the provisions of Section 251 A to S of the 1999 Constitution of the Federal Republic of Nigeria as amended. And that where a claim falls outside those provisions, the lower court must hands off and decline jurisdiction, he submitted. He went further to say that the claim of the respondents was predicated on employment disputes between the parties that arose from an alleged breach of terms of contract relating to a contract on payment of wages, crew wages. Counsel further stated that the Admiralty jurisdiction of the Federal High Court, as provided under Section 251G of the Constitution, Section 23 sub R of the Admiralty Jurisdiction Act, and Section 66, or in some versions, Section 67 of the Merchant Shipping Act, is subject, of course, as it canvassed, to Section 254C and Section 1 sub 3 of the Constitution. He submitted that so far as the provisions of any law proposed to confer jurisdiction in respect of wages and labor matters on the lower court, the provisions remained null and void to the extent of their inconsistency with the provisions of Section 254C sub 1 of the Constitution, which provides, purports, or which indeed had given this jurisdiction concurrently to the National Industrial Court. He then urged the courts to hold that crew wages related to labor and employment matters, as contemplated and envisaged by Section 254C of the Constitution, therefore overrides Section 251. So it was more like a juxtaposition of 254C of the Constitution against 251G, which was later in time, which clearly donated Admiralty jurisdiction to Federal High Court. And if you remember what was held in this Court of Appeal decision in MV Panama's Bay and Olam Nigeria PLC, 2004, 5 Nigeria Working Law Report, Part 865. I recall that the Court of Appeal held there that when there are two provisions in a statute, and one is specific and the other one is general in nature, the one that is specific, will take precedence. So in as much as it is given that 254C1 purports to have donated this admiralty jurisdiction, which the Federal High Court originally retained from 251G, it can clearly be said that when it comes to the issue of maritime level, as it were, it is arguable that the specific provision should actually be the Federal High Court. But let's not go into the details of that. So Dr. Lani Bekwese and also argued that it was wrong for the lower courts to invoke the provisions of Section 254C1G of the Constitution and Section 91, as my Lord Kanye had mentioned, of the Labour Act, to oust the jurisdiction of the National Industrial Court and to proceed to erroneously assume jurisdiction over the claims of the respondents. He maintained that the relief sought by the respondents anchored on wages due and owed, and therefore, in the context of the action, the claim has no bearing whatsoever with Section 254C1B of the 1999 Constitution. Remember, 254C1B is the sub-unit of the section that refers to Labour Act and other labor enactments. Rather, the most relevant provision that Senior Counsel submitted, the most relevant provision appropriate in the circumstances should be Section 254C1 A and K. Learned Counsel for the respondent in her argument referred to the provisions of Section 3 of the Administrative Jurisdiction Act and stated that what allowed the lower court to assume jurisdiction on the claim of the respondent was the fact that the first appellant, that's the vessel, was domiciled in Nigeria at the time they instituted the action. She further explained that the claim of the respondents was a general maritime claim that was secured by a maritime lien, as it were, that attaches to the first appellant like a leech, and maintained that maritime liens attached to a ship, notwithstanding any change in ownership or registration. The only thing that can extinguish maritime lien on a vessel is where the vessel has been scrapped and the vessel is totally destroyed. As it were, there are decisions that say that even where there is an accident on a vessel and some part of the vessel is still has been salvaged, a maritime lien will still attach like a leech on that aspect that have been salvaged, be the hull or whatever. Okay, so on the ruling of the Court of Appeal in resolving the issue referred to the specific provisions of Section 254C1 A to K, which for purposes of time, I would not, we cannot read that in our convenience. Yeah, the court held that the interpretation to be given to the above provisions of the Constitution is the literal approach, as the draftsman did not mince words, and that it was the intention of the draftsman to confer jurisdiction on the National Industrial Court to the exclusion of all other courts within jurisdiction, pursuant to Section 251, 257, and 272 of the Constitution. The court referred to several cases. So accordingly, the court held that it is the general principle of law that the primary determining factor of jurisdiction is the plaintiff's claim, as we all know. I just want to highlight the reasoning, of the court. It is important to note that the court actually agreed that Section 251G and Section 2 sub 3R give the plaintiff a right to approach the Federal High Court. But the summary of what the court held is that in consideration of Section 254C1 and the sub-provision, that it cannot be imagined that the NIC does not have jurisdiction. So in summary, the Court of Appeal consequently allowed the appeal and set aside the ruling of the Federal High Court, which dismissed the set aside the ruling of the Federal High Court, which dismissed the appellant defendant's motion or application at the lower court seeking to discharge the order of arrest, which was obtained pursuant to the in rem right that the plaintiff and respondent had at the lower court. Thank you very much. Yeah.
Thank you very much, Alonso. We appreciate that concise, masterly analysis of the facts, the background fact, the robust argument on both sides, and the decision of the court. Even though I think as you draw to a close, or you drew to a close, the spark in your voice just seemed to have gone on a very low tempos, which perhaps seems to suggest what your perspective would be on that. I mean, by and large, I mean, one thing we cannot take away, even though I think that you try to get into maritime law and related issues that perhaps could have been substantive, is the fact that it was a decision that was solely squarely on jurisdiction. I mean, a number of issues were raised, but the courts ended strictly on jurisdiction. And as an aside, I was surprised that in the lead was Justice Gumel. Justice Gumel came from the Federal High Court. And if the position was that used to be, it was preserve that court for perhaps maybe the court could have gone into or the other issues to just find a way around to determine one way or the other that, okay, the event that were wrong. But I mean, I cannot fault or go into all that because I know the discussants would do justice to all these aspects. And this is where I'm very particularly excited to bring on stage Dr. Dapola Nikweku. Well, how do I introduce him? Let me say this, like I told him, I was surprised that he was leaving what I thought was where he was very comfortable with, which is banking law, practice in the banking areas. He's published a book, he's done a number of articles, he's publishing banking law reports. And then the next thing I see him in labor and employment to, as it were, take a slice off the table of maritime practitioners and assure labor and employment practitioners that as long as it is anything to do with employment, it is the NICN. So that is really what he's done in this case. Dr. Oladipekun, by way of additional introduction, was elevated to the rank of the Senior Advocate of Nigeria in 2015. He's practiced widely. He's served as a member of the National Editorial Committee of the Nigerian Bar Association, as well as the Legal Practitioner Disciplinary Panel of the NBA. He's been a lecturer at the Department of Commercial and Industrial Law at the Faculty of Law, University of Lagos, where he had his LLB before the master's degree from Queen Mary University, where he equally obtained his PhD. Dr. Oladipekun, I invite you on stage, and then, of course, I know you have quite a number of things to say and share your perspective. One thing that I want to pointedly put to you is this. This is an all-important decision. It's in the hierarchy, in the judicial hierarchy, we now recognize that this is the final court. And the final court in labor and employment matters, well, except in very limited instances that you can still approach the Supreme Court, has said that, given a literal interpretation to 254, has said that it is the industrial courts, everything labor and employment, maritime, and wherever it may probably come from, it is the industrial, and it's the National Industrial Courts. And I must commend the court took time to examine the robust argument you put forward. And at some point, I think I just took the view that it was everything you just went to say in court that the court just gave, because I saw that after the analysis of the argument, it's about 41-page judgment, and in about 36 pages, it was the last 2-3 pages that we got the conclusion or the decision. And the decision was even the minutest detail of how you were bold enough to tell the court that, look, the lower court failed to look at 254, and it was recorded there. But in all, do you think this decision is correct? As you share your perspective, I think it's something I want you to analyze or look at beyond what we now know is a literal interpretation. If you're to take a step forward, let's hear from you. So you have the floor, Doctor. You're muted. You need to unmute yourself.
Apologies. Thank you, Mr. Kuti. I should start by standing on the existing protocol, as we say, and particularly to recognize my Lord Justice Kanye, the President of the National Industrial Court. As soon as I saw him, my immediate thoughts were that, well, now that Justice Kanye has spoken, what am I going to say? I think the last time I had this experience was, I think about 3 years ago at the NJI, when I was invited to speak. And then I saw Justice Kanye, indeed we sat next to each other. And after he had spoken, I appeared unprepared because I just had to repeat everything he had said. It was just a coincidence. And I recognize everyone. I'm grateful for this opportunity to share my perspectives. I'll just answer your questions very quickly. Do I think the Court of Appeal was right? Of course, yes. I can't think otherwise. Otherwise, I would be losing business. And I should say to you very quickly also that the matter can go to the Supreme Court. I do not think that the Court of Appeal is the final court here. My understanding is that the Court of Appeal will be the final court if the matter originated from the National Industrial Court. It originated from the Federal High Court. So I don't think there is any doubt as to the jurisdiction of the Supreme Court, so rather as to the right of appeal, the further right of appeal of the respondent to the Supreme Court. Again, just very quickly as to what I was doing in the maritime matter. If you know me very well, you would know that I've been following Dr. Olawanyi for a very, very, very long time. I followed him so much that you see my head, and I took after his boldness as well. When you see him, you would understand that. So that shouldn't be surprising. And I'll quickly just justify why I think the Court of Appeal was right. It was an appeal on jurisdiction, as you rightly stated. And as we know, it's quite elementary that in determining jurisdiction, there are two things that the court has to look at. One is the claim of the plaintiff, and the second is the enabling law. So you look at the claim to determine the subject matter, and then you look at the enabling law. And in this particular case, the statement of claim was, was the statement of claim, not very lengthy. But one thing that was very clear from the statement of claim was that the words employment, appointment, remuneration, if I remember correctly, pay slips, were recurring decimals in the statement of claim. And then, of course, the relief is very important for this purpose as well. I think the principal relief there was for a claim for wages outstanding and due. Now, if you look at those two, it becomes a very clear-cut question of whether it's the National Industrial Court or the Federal High Court that should have jurisdiction. And I think what the Court of Appeal had to consider there, and indeed the trial court as well, was first the provisions of Section 254C, subsection 1, paragraphs A and K in this particular case, weighing that against the provisions of Section 2, subsection 3 R of the AJA, and then Section 66 of the Maritime Shipping Act. And I think that's a no contest. Section 1, subsection 3 of the Constitution is very clear. The Constitution is supreme. I don't think there's any argument about that. And so that was easily decided, and I don't expect any controversy around that. Now, where the controversy might probably arise is when you now want to weigh Section 254C, subsection 1, against Section 251, subsection 1, paragraph G. And I hear the reviewer quite well when he says one is specific and the other is general. And as soon as I heard that, I just thought, oh, I need to look at Section 251, 1G again. And I don't see anything specific there. It says maritime claims, very general. I think if you're looking at specific and general, in that context, Section 254C should be the specific provision, and Section 251, subsection 1G should be the general one. Indeed, if you look at Sections 1 to 3 of the AJ, you find that crew wages is just a minute bit, a specific bit of what you call general maritime claims. So Section 251, subsection 1G does not mention crew wages at all. You have to go to the AJA to find that there. And again, invariably would have to go back again to the question of the supremacy of the Constitution. I think what is important in terms of weighing both sections against each other is to look at the words that my Lord Justice Kanye has rightly identified. First is the word notwithstanding used there. Again, it's not a question of an earlier provision and a latter provision. It's the word notwithstanding. And the law is very clear on that, that when that is used, then it means that the provision that contains the word notwithstanding actually takes precedence in interpretation and application over the sections that have been specifically mentioned. Section 251 is one of the sections mentioned there. So it shows that you are to read Section 251 subsection 1 subject to Section 254 subsection C. I think another word that is instructive is the repeated use of the word any, and any. In fact, in Section 2, in paragraphs A and K, we find those words used there to show, any employee, any employment claim or something like that, which shows you that the jurisdiction that the draftsman intended to confer on the National Industrial Court is an all-encompassing jurisdiction when it comes to the issue of wages and indeed employment. I think if you even look at Section 254 subsection 1, in my opinion, the draftsman could have stopped at paragraph A. If you look at paragraph A alone, I think it shows the all-encompassing nature of the jurisdiction. And I should say something very quickly in fairness to my Lord Justice Faji. I don't think my Lord disagreed with any of the things I've said so far. Indeed, if you look at the ruling of the court, which was one of the things we pointed out to the Court of Appeal, all of these points were made by Justice Faji. I think where my Lord then disagreed with us was that my Lord then applied the provisions of paragraph B, which deals with labor acts, and then he then went into Section 91 of the Labor Act to then exclude crew claims brought by crewmen for crew wages. And for us, the point was simple. That would be in a case where the subject matter of the claim before the court deals with the Labor Act. The issue of Labor Act or the Labor Act was a non-starter in this case. And it's important that I say that, because if you look at the ruling, you find that my Lord Justice Faji emphasized the provisions of the supremacy of the provisions of the Constitution. I think another point I should mention, I have heard arguments on the other side with respect to the provisions of Section 66 of the MSA, saying that, well, claims by seamen, such claims constitute a maritime lien. And so because they constitute a maritime lien, then it should go to the Federal High Court. But it's important and it's instructive that we look at the opening words to Section 66. It says the following claims shall be secured by maritime liens on the ship. So it's very clear that the matters listed in Section 66 are meant to secure the claim. So in other words, the court must have jurisdiction in respect of the substantive claim before you start talking about security. That again is elementary law, that the court cannot secure the claim if it does not have jurisdiction in respect of the substantive claim. So I think the issue of maritime lien does not even arise, if at all there. There was also the issue of the decision of Idris J, as it then was, in MV Clover Pride, which Honorable Justice Faji had asked parties to file supplementary addresses on. That was addressed because Idris J, as it then was, had emphasized the superiority of the Constitution and of Section 254C. I think somehow after filing the addresses, we didn't get a decision on that point. And we felt that if there is an earlier decision of the court, that there are three things the court can do if you're not going to be bound by the decision. You have to distinguish, you overrule, or you depart. None of those three things was done in this particular case. And if you look closely at the Court of Appeals judgment, I think that was one of the bases. That was the basis on which the appeal was allowed. I think I'll just stop here on this point. Usually with issues of jurisdiction, we find that, especially with the Federal High Court, we find a decision like this that we think settles the point. And it is not yet clear if the respondent is going to exercise a further right of appeal to the Supreme Court, which I am convinced that they have, because the matter originated from the Federal High Court. But I think that tomorrow, next month, whenever, some persons will still try to test the waters, as it were. Of course, we lawyers do this, and then at the end of the day, we might have conflicting decisions. I should just draw something out very quickly. So the Court of Appeal did not just allow the appeal. They also then performed a constitutional duty with that. If you look closely at the judgment, the Court of Appeal has now declared the provisions of Section 2, Subsection 3R of the AJA as void. So as we speak, that section does not exist. Again, I think I'll leave it there. Thank you.
Not at all. With due respect.
Wow. Thank you so much, Dr. Olanipeku. You caught me off guard. I was flipping through the judgment to perhaps spot the particular point you made last, that the Court of Appeal had gone ahead, step to declare those sections void. I do not seem to think so. But I mean, it's something we'll come into when we share perspective, because I look at pages 37, 38 specifically, and it appears that what was applied here was more of a judgment that is in rem in relation to jurisdiction when it comes to the industrial courts, wrestling jurisdiction of the industrial court away from the Federal High Court when it's maritime claim and all of that. But outside that, I struggle to perhaps locate where the court had gone ahead to, or it could be inferred that in effect, those sections, but we have a bit of time to go into that. I must thank you. Very insightful analysis and then incisive comments, and the conclusion that you've reached that, yes, the decision is absolutely right. And again, I must share that you are right. Initially, I forgot for one moment that, it was a decision that came from the Federal High Court and not from the Industrial Court, even though it was that part of employment that had gone up. I would now, but before I call on Dr. Olanwoye, who I'm quite excited to bring on stage now, but before then, let me specially recognize the presence of Honorable Justice Peter Afen, who are actually of the High Court of the Federal Capital Territory, and then who had shared a bit of the thoughts. And I wonder if my Lord would be kind enough to say a few things. Otherwise, we could just go on. There is a part of a rich and incisive paper, well-researched paper that my Lord had delivered, Judicialism in Nigeria, gasping for breath under our watch. At the appropriate time, I want to make a reference to why I think there is an interesting portion of that paper that deals with, or that could easily resolve all these issues that we're dealing with. And we're still back on this jurisdiction, but I'll come to that. My Lord Justice Afen, you want to come on stage, my Lord? All right. Okay. The president appears to want to say something before I call on Dr. Olanwoye. Because I saw that my Lord immediately.
Not yet.
Okay, we'll come to that. Thank you. Now, Dr. Olanwoye is a big masquerade. In the true sense of the word. When I say he's a big masquerade, he's not just a teacher. Like I've told him, he's a practitioner in this area. And unlike Dr. Olanipeku from financial background, law, Dr. Olanwoye's PhD is actually in the area of Admiralty and Maritime. And I think he already foretells what his position would be as to which court to go to on Admiralty. But outside all of that, it's interesting that when the idea was mooted by Ireland to have this, it came at a time when I just happened to a thesis, a paper that Dr. Olanwoye had written on this issue, called Unintended Consequences of Section 254, and it's published in Gravitas Law Journal, which interestingly was only released yesterday, but it actually been all in circulation that it was coming out. before now. And I had a scan through the paper, and it was interesting that even though the paper was written before empty purpose decision came in March this month, virtually all what the concerns, the fear that they had allayed and all of that eventually played out here. So I felt no other person but Dr. Olawanyi to come in and give us his own perspective on the decision, one, and generally on the jurisdictional issue or struggle, just like the Federal High Court 1973 till date, Federal High Court and State High Court ascertaining with exactitude which court to go to, which had produced quite a number of cases in all the specified areas that even though the Federal High Court had been conferred with, the limited jurisdiction of the State High Court had often been raised and touted in many fact scenarios before the court, I mean both courts, to say no, you should go to the State High Court, it should be at the Federal High Court. It appears that is really what is playing out now, or that is about what we're going to launch into. And but let me not preempt. Dr. Olawanyi, please, you have the stage, sir.
Thank you very much, Folabi, and let me again thank Elan for giving me this opportunity. As I said to you this morning, I had written a paper on the issue, and lo and behold, the judgment came out. I was meaning to engage with Dr. Olanikpekun privately when you told me that you are thinking of this. So I thank you for the opportunity. Let me also start by thanking my Lord, the President of the NIC, for joining, and all the other judges of the NIC, and also Honorable Justice Peter Afen, JCA in waiting. I thank you all. As you said, my remit is essentially to try and persuade us that the decision of the Court of Appeal in the empty and purpose is wrong. And I will seek to persuade the participants about this. But let me just say that I will start by, first of all, talking about the areas of agreement I have with Dr. Olanikpekun and perhaps the Court of Appeal itself in terms of the judgment in the empty purpose. And then before I then give my own analysis of what I think the decision ought to have been, I would also give a bit of context around the essence of Admiralty jurisdiction and why it is extremely important that wherever possible, Admiralty jurisdiction is maintained in the context of cruise wages and salaries. So of course, Dr. Olanikpekun argued, and I agree with the Court of Appeal, that the question of jurisdiction is a function of looking at the statement of claim and the reliefs being sought. No argument about that, because that's a question that is determinative of jurisdiction. But when you look at the claim as Mr. Azi has set out, you will see that in as much as you want to argue that having regard to section 254C1, the essence of the claim is for wages and salaries of some employees, then it comes within the subject matter jurisdiction of the NIC. But also, when you look at the claim, it is also a claim that comes within the subject matter jurisdiction of the Federal High Court, as set out in section 23R of the Admiralty Jurisdiction Act of 1991. And I will touch on a point that Dr. Olanikpekun held on to very strongly, and which is a function of a matter of constitutional interpretation and the history of the constitutional wranglings between the Federal High Court and the State High Courts, and certain lessons that we learned from that. But I'll come back to that in a minute. Now, the second area of agreement, and Folabi had referred to the article that I had written on which the article was prompted by the Federal High Court decision in the empty sum purpose. And then I reviewed a number of other cases. And the article, like he said, just came out yesterday. And one other area that I agree with, and which I state clearly in that article, is the fact that I also do not agree respectfully with Justice Faji that the Section 91 of the Labour Act had any relevance in the grand scheme of things in this case. So on that score, I also disagreed with Justice Faji. But I agree, and I would again say that I will try and persuade you that his ultimate decision to still retain jurisdiction is a correct one. Now, where are the areas of divergence in terms of my own view about the decision in the empty sum purpose? The Court of Appeal essentially in that case decided on the basis of Dr. Olanikwekun's submission that the Constitution in this case, on the particular facts of this case, should be construed literally. And that is where I disagree, and I'll come to that point in a minute. And every other thing that the court said in that case stemmed from that basic premise of interpreting the Constitution on the basis of the ordinary meaning of the words used. So it was then easy for the Court of Appeal, and it was easy for Dr. Olanikweku to persuade them that, oh, Section 254C1 has overriding effect over every other section that deals with jurisdiction of the other courts, particularly the Federal High Court, because of the language of Section 254. Now, if we limit ourselves to that literary interpretation, then the decision is correct. Absolutely, the decision is correct. There'll be no question about the fact that with the introductory sentence and the use of the notwithstanding and the specific reference to Section 251, that settles the matter. But with due respect to the Court of Appeal and to Dr. Olanikweku, I do not believe that the matter should end there, because in this particular case, the essence of the argument was to divest another court of jurisdiction. And in that situation, the interrogation should have been a lot more rigorous and deeper than what was done in the empty sum purpose. And why do I say that? At the end of the day, the issue relates to the question of exclusivity of jurisdiction. And my thesis, my submission, is that to the extent that the issue before the courts was the question of tensions about jurisdiction between two courts, that we know that historically we dealt with in the days of the Federal High Court and the State High Courts, we managed to resolve that problem constitutionally. And whether or not the issue of subject matter jurisdiction should be embedded in the Constitution is a discussion for another day. But as we have it, it's been embedded in the Constitution. But Dr. Olanikweku touched on a point, and which he argued vociferously in the appeal, which was that really the issue about crews and masters' wages and salaries was not expressly stated in the Constitution under the jurisdiction of the Federal High Court. Now, I concede that point as a general proposition, because when you look at Section 251G of the Constitution, you see that it only just mentions admiralty jurisdiction, but it does not expressly state or give us instances of those causes of action that come under what we mean by admiralty jurisdiction. And then the courts have historically looked to Section 2 of the Admiralty Jurisdiction Act to determine the contours and the limits of Admiralty jurisdiction. And that is why you then have sections like Section 2(3)R that says that master's crews, any claim that relates to master's crews and wages comes within the Admiralty jurisdiction of the Federal High Court. It is an Admiralty matter. It is a maritime claim. Mr. Azia talked about the two forms of maritime claim, the proprietary maritime claim and the general maritime claim. But more importantly, before I then emphasize my main point, is the importance of this jurisdiction to a small section of employees. Not only is their claim regarded as a maritime claim, it is also a claim, as Dr. Lanikweku says, that attracts a maritime lien. And what that means is that this crop of employees have the right, when they have a cause of action, they can go to any court to ventilate their cause of action. But the beauty of characterizing their claim as an Admiralty matter is that they have the ability, as Folabi has said, to arrest a vessel as pre-judgment security. So even before they start their action, they already have the comfort of a security that if they are successful, they can attach, simply because the owners of vessels are in faraway jurisdictions, and the vessels that may have caused the damage, and in this case, the vessel that they have worked on may sail to another country, and they don't have the opportunity of holding on to that vessel. So that is why, apart from being a maritime claim, it attracts a maritime lien, which means that if that owner sells the vessel upon which they've worked and for which their salaries are owed, they can still attach that vessel in the hands of an innocent purchaser for value without notice. That is the beauty of the maritime lien. So that is one important advantage that the crew of a vessel as employees of a ship owner have, and that is the potential benefits that will be taken away if the Federal High Court cannot exercise jurisdiction, because the NIC doesn't have jurisdiction to order the arrest of a vessel. It's an in rem order that is made, not an in personam order. So what is my submission about what the results or what the decision ought to have been in the MT San Purpose? My proposition with respect to the Court of Appeal and to Dr. Lanikweku and other proponents in favor of is what I call a very, very simplistic interpretation of the Constitution. What you see from the decision in the MT San Purpose is what I characterize as binary thinking. It's either this or that. But to the extent that the jurisdiction of another court is being questioned and potentially being taken away, I thought that the court ought to have looked beyond the premise upon which they came to that decision. We have to bear in mind that in as much as the president says that the NIC is a court of special jurisdiction, the Federal High Court too is a court of special jurisdiction. It is extremely important to bear that in mind as well. And then the question then arises that when the National Assembly passed the Third Alteration Act, could anybody think that they intended to deprive the Federal High Court of this jurisdiction that they exercise in respect of claims for wages and salaries by seafarers and crewmen? I think all of us, in all honesty, will say that if this had been brought to the attention of the National Assembly, they would have said, oh, gentlemen, can we not just carve out these small people? Because we are not disputing the fact that we want all employment matters to go to the National Industrial Court. But if we have a court that by its very nature has certain procedures that are special to it, to assist employees in the pursuit of their legitimate claims against an employer, do we still intend to take this jurisdiction away? Now, my respectful submission is that I do not think that the National Assembly intended to divest the Federal High Court of this jurisdiction that they had hitherto exercised as an admiralty matter. And what then is my proposal as the solution to this matter? As I said in the beginning, this issue is an issue of possible jurisdictional wranglings between two courts of special jurisdiction. And my proposition, which I make in the article, is that the decision of the Court of Appeal should be one that recognizes the concurrency of jurisdiction of the Federal High Court and the National Industrial Court. And I'll tell you why. It's not just an easy proposition, because, like I said, I concede that upon a literal reading of Section 254C1A and K, there is no argument that it seems that the National Industrial Court is vested exclusively with jurisdiction to deal with employee matters. But Section 2512, in its own way, also uses that language of exclusivity as well. But as I said, Dr. Lanikbekun prompted the Court of Appeal, and the Court of Appeal accepted the proposition that the interpretation of the Constitution should start with a literary interpretation of the ordinary meaning of the word used. And they ended it there. And with due respect, that is where I think that it got this decision wrong. It is noteworthy when you read the decision in MT Sampopos that all the seminal authorities on constitutional interpretation were not cited in that case. You did not see any reference to Nafiu Rabiu and State. You didn't see any reference to Elelu Halilu against Attorney General Federation. You didn't see any reference to the recent decision of the Supreme Court in Skybank and Iwu, where you would see clearly the attitude of the Supreme Court about the interpretation of the Constitution. The premise that the Court of Appeal relied on is only the starting point of constitutional interpretation, but it doesn't end there. And especially in a situation where you are now dealing with the jurisdictional question between two courts of special jurisdiction, the interrogation should have gone well beyond that. I would just refer us in your spare time to go and read the decision of the Supreme Court in the classical case. We've already before, but sometimes when we are faced with situations where we need to apply these cases, for some reason, we just don't apply these cases. Everybody knows about Nafiu Rabiu and State. But more importantly, when you look at Elelu Habib against Attorney General Federation, you will see the Supreme Court listed the guidelines for interpreting the Constitution. You will see it clearly there. And one of the things that they say there, for example, they say, effect should be given to every word used in the Constitution. A construction nullifying a specific clause in the Constitution shall not be tolerated unless where absolutely necessary. But listen to this one. The principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, should measure the purpose and scope of its provisions. Words of the Constitution are therefore not to be read with stultifying narrowness, which is exactly what the Court of Appeal did in the MT Sampopos. And this is what Justice Nweze emphasized in Skybank against Iwu as well. He said it clearly there, and they relied on some English authorities which talk about the fact that in a situation where a particular court, for example, has been exercising jurisdiction and Parliament wants to take that jurisdiction away from that particular court, it must be done expressly, without a shadow of a doubt. And on that basis, if the Court of Appeal had applied the long line of seminal cases on constitutional interpretation, they will have gone beyond the premise upon which they decided the empties and purpose. And if they had done so, in my respectful opinion, I believe they will have come to the conclusion that the best way forward, the best interpretation that we can give to this potential constitutional dissonance is concurrency of jurisdiction between the Federal High Court. Now, what I'm suggesting is not in any way disruptive because it recognizes the jurisdiction of the NIC and it recognizes the jurisdiction of the Federal High Court. And the jurisdiction of the Federal High Court is limited to only members of the crew in respect of their crews of wages for their employment on a vessel. So that even the ordinary staff of any shipping company cannot say that they're going to the Federal High Court to ventilate an admiralty matter. They will go to the NIC. So the crop of employees that we are talking about are extremely limited, such that it cannot be argued that my proposition would have such a disruptive effect. And what I'm advocating here is no more than judicial committee between the Federal High Court and the National Industrial Court. This matter should not, in my humble opinion, generate the kind of heated debate that is already out there when we can resolve this thing by what I call judicial constitutionalism that we have seen evolve over the years and which was applied by the Supreme Court in Skybank and the EU case. So my final submission is simply that I hope this matter goes to the Supreme Court because clearly, and as you can imagine, I would like to be an amicus in that case, so that the Supreme Court has a full view of what the issues are and what the potential arguments can be. So I again agree with Dr. Lanipe that this is a matter that can go to the Supreme Court, and I hope that it goes to the Supreme Court. And at the end of the day, I hope that the Supreme Court will settle this matter like they did settle the matter in the days of the Federal High Court and the State High Courts until we had the constitutional change of the concurrency of jurisdiction argument. And that, I think, is possible in this case, despite the language of the opening paragraph of section 254C1, which in my humble opinion, despite the use of the notwithstanding, and like the president has said, and was used about 42 times, but I still don't believe that the National Assembly would have intended and did intend, even with the language of section 254C1, to divest the Federal High Court of jurisdiction in respect of claims for wages and salaries by the crew and seafarers as a matter of admiralty jurisdiction in Nigerian law. I think I would pause there.
Thank you, Doctor.
Thank you very much.
Doctor, I'm sure you are short your time, but I just couldn't stop you. My Lord, the doctor was quite cerebral, and then I thank you for very practical, imaginative solutions that you become preferred, and very quick to identify what I readily agree appear to be the gaps in that decision, which to start with is there was no analysis, no thorough analysis of the seminal decisions that the Supreme Court, and I thank you for citing Nafi Rabiu. Nafi Rabiu, Idigbe at brilliant best. You see, it took the approach before coming to the conclusion that when it is the Constitution that is being interpreted in fact scenario, it has to be purposive interpretation, broad, and not necessarily the literal interpretation that you take on that will be the position. So I think that was one major error. And then to add to it, amicus should have actually been called to perhaps come and assist the court with different perspectives so that the courts will probably be able to come to some conclusion. But it appears is increasingly the case now in the appellate court, because even Skyback and Ewu fell short of that. But a little away from that, I like the conclusion that is what is practically the circumstance. Concurrence of jurisdiction being shared as between the Federal High Court and industrial courts on matters relating to maybe wages and related maritime labor claims. And I recall that indeed that was really what even before the constitutional amendment, a number of cases when the 73, when the Federal High Court was created in 73 and around 78, thereabout, generated quite a number of heated legal debate as to the jurisdiction to go to, I mean, the appropriate fora to go to in banker-customer relationship and all of that. All those line of cases, Bronick Motto, Wema Bank, Jamasi Structure, ECB, before it eventually came to the conclusion that let's explore having the two courts share concurrent jurisdiction in both cases. So I thank you, and Doctor, for that very robust presentation. Before I go on, permit me now to kindly invite the Honorable Justice Peter Afen, JCA, in waiting to, let's say, his perspective on the case and related issues related to it. My Lord, you have the floor.
Thank you very much, Folabi. And permit me to do obeisance to my Lord, the President of the National Industrial Court, and all of the subject matter experts, Dr. Olawonyi and Dr. Olanipeku, who both of whom I've enjoyed listening to and for whom I have a lot of respect. I'm a generalist judge. I'm not a special judge like the NIC or the Federal High Court. But this is a matter that's of interest to a whole lot of us. Well, for me, who probably would now be sitting over matters from the Federal High Court, by the grace of God. I had a discussion with both Folabi and the President of the National Industrial Court in the wake of the decision handed down by Justice Faji on what I called the unintended consequence of the constitutional amendment that has conferred nearly, well, unlimited, as it were, jurisdiction over employment and employment-related matters, including crew wages. And my position on this has always been that we could harmonize the jurisdiction of the National Industrial Court and that of the Federal High Court relative to crew wages without doing violence to the letter and spirit of the Constitution. And so I would cast my lot with the position just brilliantly expressed by Dr. Olawonyi. And I mean, I take the simple example. What's the benefit of going to a court if you are clearly unable to harness its fruits? And given the short duration, especially foreign manned vessels come into the country and then the crew are, probably not paid and they need reprieve legally. Strictly speaking, the National Industrial Court is not in any position to give reprieve to hapless crewmen in those circumstances. And so I think that a robust interpretation of the Constitution in that decision could have saved that aspect of the admiralty jurisdiction of the Federal High Court. Not necessarily to argue that the NIC is bereft of the jurisdiction, as Dr. Olawoyin has pointed out, but for purposes of efficacy, and the purpose of the Constitution not being defeated. I would ordinarily have looked at a situation where jurisdiction, especially as it relates to foreign vessels who have sailed into Nigeria, will be ceded in favor of the Federal High Court, and to that extent, jointly exercising jurisdiction depending on judicial efficacy, would have been the way out. So I think that this is a debate that we must continue to have. And as Dr. Olanipekun pointed out, probably the Supreme Court would have the opportunity to have the final word on this, because that, I do not think, is the intendment of the makers of the Constitution, to, as it were, take everything from the Federal High Court in respect of this narrow aspect of crew wages and workers' salaries and all of that, and sit to the Federal High Court, which is not in a position to immediately donate utility to those who would be going to that court for the kind of remedy that is here. I just want to say that I've enjoyed the discussions. Even though I asked for Labi not to drag me in, he will not let me be. So those are my preliminary thoughts, and I thank you for this opportunity to make this intervention.
My Lord, the intervention, which I do quite all right, to be incisive and giving, quite engaging and robust. I just wasn't comfortable sharing it alone. I wanted the whole participants to actually take a bit of what I take up, my Lord, every time there is such discussion. So, my Lord, we thank you for coming over to share your perspective. Yes, I would thank you.
We can't hear you.
And going into. So the case reviewer would like to have the case reviewer to come on stage and share his perspective. We try to limit him earlier on to just a general review, even though it was easy to tell where he was coming or what he's here to say as per his perspective.
Okay, thank you for giving me a second bite. And I must thank Dr. Olawoyin, who incidentally was my supervisor at Unilag when I did my LLM. So the point I need to highlight is taking up from where Dr. Olawoyin left it. It's a fantastic submission. The Court of Appeal used this terminology, maritime labor claims. If you consider maritime labor claims, it is so large. Dr. Olawoyin made a fantastic point that if an employee of a shipping company has a dispute or an issue against his employer, the natural court to go to is the NIC, because his claim does not enjoy the sacrosanct and sacred characteristics that a claim for crew wage has. Let me, as early as 1898, there was this American case for us to understand, the fact, the issue that Dr. Olawoyin has raised, that this matter, with due respect to the court, was not properly trashed. In 1898, there is this case of the John G. Stevens, 170 US 113. The Honorable Judge had this to say. He said, seamen's wages are sacred liens, and as long as a plank of the ship remains, those days ships were built with plank or wood, the sailor is entitled against all other person to the proceeds as a security for his wages. Then, in constitutional law, I was taught that for you to understand how to interpret a constitution, you may have to refer to the Hansard, the discussions that the legislators had at the floor of the National Assembly when they were trying to make the third alteration to the Constitution. Had this fact of sacrosanct, sacred maritime lien, which inures naturally to crew wage, we should remember that the lien that a crew wage has, the lien that a crew has over his claim for his wages does not operate as a matter of contract. As a matter of fact, there is this case in Lloyd's Law Report where someone had procured a ship fraudulently and had somebody work on the vessel. The court held that the right in rem, which gives a crew wage a lien on a vessel, is tied to the services rendered. It does not matter how the relationship comes across. Dr. Olanikbeku made reference to that the claimants at the Federal High Court mentioned employment, contract, and all that. Just to buttress what Dr. Olawonyi has said, a crew or a member of a crew or a master who has a right in rem against a vessel does not need to demonstrate that by a contract dated XYZ, he was brought on board the vessel. All he needs to prove is that he had rendered services to that vessel, and thereby his right inures against the vessel. So this is just to bring it into proper perspective that, with due respect to the Honorable Court, that had it been that certain issues were brought before the court, the judgment on a literal interpretation may have been the same, but the court would have been able to distinguish that Section 254C, regardless of the word notwithstanding, if you look at the word notwithstanding literally, you will say, okay, 251 has been covered. 251 says admiralty jurisdiction, and crew wage, which gives you a maritime lien, forms part of admiralty jurisdiction. If all these issues were canvassed and trashed properly, I think the best we can have is that if you are a maritime laborer, generally speaking, and you have a claim, you work for a shipping company, you work for a terminal operator, the shipping industry is wide, you can approach the National Industrial Court for an in personam action. Let us not also forget that, with due respect, that the National Industrial Court does not have with due respect, the paraphernalia and the wherewithal to enforce maritime liens. Dr. Olanikbeku said that Section 23 sub R has been nullified. With due respect, that is, I don't think that is tenable. If a crewman approaches the National Industrial Court, the question now is, does the National Industrial Court have the right in rem, have the jurisdiction to effect the arrest of a vessel? Argument have been proffered that you can look at Order 20 of the National Industrial Court, which is attachment of property. It is in pari material with Order 30 of the Federal High Court. The State High Court also has similar provision, but it is attachment of property, and there is a hurdle you have to cross. The hurdle you have to cross is that you must demonstrate to the court that the defendant has the intention, the operative word is intention, to remove the rest from jurisdiction. So it is discretionary. The arrest is not almost automatic as we have in Federal High Court. If you have a maritime claim and you approach the Federal High Court, the arrest, just like we have it in UK, is automatic as good as it. Why? Because in applying for an arrest for the ex parte order, you are giving an indemnity to court that if the arrest turns out to be frivolous or uncalled for, damages will inure against you. If you approach the NIC to arrest a vessel pursuant to this judgment, as it were, on what basis? Because attachment of property is not the same. So in final analysis, the point that maritime practitioners are trying to make is not that we feel threatened that our jurisdiction is being, or as it were, because it's a national jurisdiction, is being taken away. The point is that if at all it has to be tampered with, let it be that all the contours and dimensions of the issue have been analyzed. And what is important is that examining the historical background of maritime liens, which is automatic, which attaches to a vessel, even when you sell to another party, as Tolani has stated, even when you sell to an innocent party, that right keeps traveling with that vessel. The only thing that can extinguish a crewman or master's claim for his wage is when the vessel has become a total write-off, a total loss. I have said it before that even when a vessel has had an accident and a part of the vessel is still salvageable, that the maritime person who has a maritime lien can still proceed against what is left of the vessel. So I just hope that if the respondents go to Federal High Court, the constitutional lawyers, maritime lawyers, in the interest of national jurisprudence, will be invited as amicus curiae to place the issues in proper perspective. It is not a struggle for jurisdiction. It is a struggle to ensure that our jurisprudence follows international best practice. I did a random search, and I can tell you for free that this challenge of Federal High Court jurisdiction for crew wage claims is only been challenged in Nigeria. We copied this law from international convention. Maritime laws flow from international convention. The AJA was fashioned against the Convention on Arrest of Seagoing Ships.
Okay.
It is only in Nigeria. So in summary, I just hope that this matter will go to Supreme Court and that all the analysis, as Dr. Lanwin has mentioned, will be brought to bear so that we can arrive at an equitable and most proactive and practical solution.
Thank you very much, Nonso. Let me just draw from your conclusion that, you hope it goes to Supreme Court and perhaps we get a lead as to how this should be determined or how this should go. That's a final court in the hierarchy. Fantastic.
Yeah.
But as you said that, I recall that not too long ago, a couple of years back now, a retiring justice of the Supreme Court in a valedictory speech had raised a major point of concern. And what was the concern? It had to do with the scarce judicial time and resources that increasingly was being spent on the perennial objections as to jurisdiction. That in itself would account for a significant proportion of the delay that we talk about in the justice delivery system. So it did not only identify that problem, of course, it provided a solution. And the solution, you suggested, let's go to the Supreme Court. Let's go to the Supreme Court. Everybody Supreme Court, everything Supreme Court. Matrimonial court, Supreme Court. Land matter, Supreme Court. Then why don't we think of having all courts of first instance as courts of unlimited jurisdiction? We're leaving out the magistracy. The Federal High Court, the State High Courts, National Industrial Courts, IST, all should be able to examine maritime cases, should be able to examine matrimonial causes and all of that. That the moment that is done, you find out that 70% of lawyers will be out of job. I just had that portion because the time being spent on objection, and you've seen, this is talking about jurisdiction again. Interestingly, in 2015, Justice Affed delivered a paper, and my Lord knows that I like referring to it. And from the topic, the heading, he called it "Judicialism in Nigeria, Gasping for Breath Under Our Watch." My Lord identified virtually all the issues the problems that you can think of, and as to the slow pace of the justice delivery system, while it does appear that litigation in this part of the world is all about all motion, no movement. And almost aligned with something similar in preferring that, let's look at, okay, if you come to a court and it does appear as if that court does not have jurisdiction or the objection is raised, maybe the law should be amended to reflect properly that the court should just have the power of transferring to another court. So when it dawns on us that you cannot hang on the argument of, oh, my Lord, the Supreme Court has said in Toko and Governor of Gongola State is a claim that donates jurisdiction. Maduko Olum have said this. The moment we realize that, maybe we'll leave all chasing the jurisdictional issue and perhaps we're looking at the substantive issues. And then our law reports will now begin to go back to the days where judgments that you read in law report, they are substantive issues and all of that. You've professed Supreme Court. I would like to perhaps ask for perspective on this. Maybe I'll start with my Lord, the President, and because I reckon that in addition, the President wants to share some views about what has been said by the discussants and then the reviewer. And I'll go around. I'll ask Dr. Lanwoyi's intervention. I'll ask for Dr. Olanipeku, and I'll thereafter quickly run through the questions. Because quite a number of questions have been posted in the chat box. Thank you so much.
Thank you, Mr. Folabi.
Yes.
I've listened attentively to speakers. I have an issue. If a provision in terms of its literal interpretation admits of no ambiguity, why purposive interpretation? For me, we've done this. I'll give you a number of examples, and it's becoming worrying, the manner in which, whether at the judiciary or at the executive, we do some things outside of the words of the Constitution and try to justify them. I'll give you a simple example. The Revenue Mobilization, Allocation, and Fiscal Commission, if you read the constitutional provision regarding their power is to fix salary and benefits of constitutional office holders who are in office. I have held, for instance, that it does not include fixing benefits of those who have retired. But in actual fact, they do in terms of benefits. They recommend in terms of benefits of retirees. That's why you have in the law severance benefits, a certain percentage of your salary when you leave office. That is one. Go to section 46 of the Constitution on enforcement of fundamental rights. The rules which are supposed to emanate from section 46 of the fundamental rights, for instance, say you can apply in respect of African Charter on Human Rights. Yet section 46 talks about the enforcement or the breach of rights under this chapter. But the rules talk about enforcement of African Charter. The rules talk about public interest litigation, even when section 46 is very clear that only him whose right has been infringed can approach to a approach a high court in the state in which he is.
Yeah.
I'll read, sorry to take your time out.
Yes,
I want to read a function of the Code of Conduct Bureau. And this is what it says. Receive complaints about non-compliance with or breach of the provisions of the Code of Conduct or any law in relation thereto. Investigate the complaint and where appropriate, refer such complaints, such matters to the Code of Conduct Tribunal. I'm saying this for the first time. I sit down as head of a court. A judgment is given in Bauchi, and there's an order, pay him his salary. No figure was put. The gentleman goes and carries a writ of attachment and says, give me an order to enforce and attach property in respect of this judgment. The judge says, in respect of what? He said, the order you made, where is the figure? No figure. He writes a petition to me. I reply and say, look, the judge acted rightly. There is no figure stated in the judgment. The next thing I see is a query from the chairman of Code of Conduct Bureau telling me I should investigate and report back to him. And when I say, under what are you doing, he quotes this constitutional provision. So I go back to my question. When the literal interpretation of a constitutional provision is not in doubt, which purpose are you going to look for? Somebody talked about Hansard. Yes. In all of these cases that we are talking, including Skybank and Iwu, nobody asked for the Hansard. And by the way, I have my reservations about Skybank and Iwu. Skybank and Iwu was about right of appeal. Whether the decisions of NIC should be final or not. Skybank and Iwu said, because NIC has the power of a high court, and because there is an automatic right of appeal from high court to court of appeal, there should be an appeal. I use the word should advisedly. Now, we all know jurisdiction and power are not the same. The right of appeal inures to jurisdiction, not to power. But even that aside, nobody for once in Skybank and Iwu decided to say, let us look at the historical trajectory of the right of appeal from NIC. Many don't know it. When the NIC was established in 76, it was the 1963 constitution that was in place. And at that time, there were only two courts mentioned in the constitution: the Federal Supreme Court and the Lagos High Court. So when the NIC was established via the Trade Disputes Act of 1976, the provisions of the 63 constitution were amended and NIC was put there as the third court.
Yes.
And its decision was made final. In fact, the powers of the Supreme Court to make reserved judgments was also given to NIC. Now, because of agitation, in 1992, via Decree 47, a limited right of appeal was now made. And what was that limited right of appeal? That in respect of fundamental rights, there will be appeal, but in respect of any other thing, the decisions of NIC is final. 2006 NIC Act, Section 9, where the word only was used twice, the limited right of appeal was retained. In 2011, third alteration, go there and look at it. Again, limited right of appeal was retained in similar words. In other words, in 3 legislative instruments, limited right of appeal was retained. Yet, by a purposive interpretation in Skybank and Iwu, we were told that the legislature did not use correct words. Are we substituting individual nuances, individual likes, individual preferences to what the words in the Constitution say? Forget about what Kanyip likes. Because the moment we begin to move away from the words used in a statute or even the Constitution and replacing it with our likes, we are going to have the kind of problems we are having in the body politic. If we identify a problem, okay, amend and rectify the problem. In one breath, we say judges don't make law. In another breath, sorry to use the words of Dr. Olaoye, we talk about judicial constitutionalism. I read that as a statement suggesting that I should replace my own likes of a particular provision with or in place of what the literal interpretation is. So I go back to my question. When words used in the Constitution, when the provision of a Constitution admits of no controversy, which purposive interpretation are we doing? Should a judge substitute what he likes? There are so many things I like, there are so many things I don't like, but I'm compelled as a judge to simply keep within the letters of the Constitution for the simple fact that that is the only thing I can defend. Of course, issues have been identified. And there's one other thing I must draw attention to, just so that we are in the picture of the whole discussion. Some few years ago, Nigeria ratified the Maritime Convention. a convention made by ILO. If you go to the Constitution, National Industrial Court has jurisdiction and power to apply conventions, treaties, protocols ratified by Nigeria. This Maritime Convention is ratified by Nigeria, so it can be applied in the National Industrial Court. Federal High Court does not have that jurisdiction, irrespective of its admiralty jurisdiction. So, assuming the convention inures to the benefit of any maritime worker, including crew members, how are we going to resolve that? So yes, there can be arguments for, and certainly there can be arguments against. But for now, all of us have agreed on a literal construction of Section 254C1. This is the way to go. Any other thing we are doing is substituting our preferences. And this is where I have a problem, because we are having so many of these examples in constitutional interpretation that sooner or later, we are not going to have anything left in that constitution. Or we will have our substituted impressions of what a constitution or what the constitution says or should say. Thank you.
Thank you so much, my Lord. We've actually spent some time, so I've not engaged my Lord. We thank my Lord for the additional thought in relation to purposive and vis-a-vis having it as the literal interpretation. My Lord, we can't exhaust this, and I'm sure we'll come back to my Lord. To Dr. Lawoyi made reference to Nafiu Rabiu. In Nafiu Rabiu, decision, just to interpret decision, appeared to have been very literal and well understood. But even at that, the Supreme Court went ahead to say, there's a purpose. But we'll come to that. Dr. Lawoyi and Dr. Lanikwekun, I need your intervention in relation to the question I posed. I know Dr. Lawoyi has a 5:30 appointment, which you said earlier. So, Doctor, if you can quickly have a bite on this, or just about a reply to any of the perspectives shared so far. And after that, I'll go to the floor to ask one or two persons to, let's hear from them. I see Benga Bello, you raising hand. I'll call you shortly. Doctor, please.
Okay, Falabi, thank you very much. You know, when I was making my submission, I said that the proposition I was putting forward, in my humble opinion, is not disruptive. But I must say that your own proposition is extremely disruptive, and I'm not so sure that I'm persuaded that all the courts will just have general jurisdiction. For me, the critical question, and I sort of foreshadowed it, that I have personally had a problem with embedding subject matter jurisdiction in the Constitution rather than in a statute of national assembly. You know, so I don't have any problem with having courts of special jurisdiction like we have now, and whatever is left for the high courts to have their unlimited jurisdiction subject to the NIC and the Federal High Court. So I am a proponent for the current situation that we have in terms of specifying jurisdiction for particular courts. But, you know, for us to keep on having this constitutional arguments on the issue of jurisdiction is something that I think that we have to look at. You know, my Lord, the President has made the point. My simple response will be that I think there's just a tendency that sometimes we take certain principles as gospel without really sometimes interrogating it. And the fact of the matter is that there is no general settled proposition that the Constitution should be interpreted on the basis of the ordinary meaning of the words used. That is, I mean, that is what Nafiu Rabiu and Lelu has said. They gave 12 principles, and then even in a later case, I've forgotten the name of the case, they added another 4 principles to constitutional interpretation, you know, and that is where it was evolved, the living tree principle and doctrine of interpretation. That is not, we didn't create it. That is what the authorities say. But for me, there are certain situations in which you are interpreting the Constitution and giving the particular clauses or sections that you are interpreting, you can stop at the literal interpretation or the ordinary meanings used. But in some other cases, particularly as I emphasized, where there is the potential of the jurisdiction of another court being totally divested, you cannot stop at the literal, the ordinary literal meaning of the words used. That is just my proposition in the context of statutory interpretation. I'll leave it.
Thank you so much, Doctor. Dr. Laripepo, your thoughts? Okay. Dr. Laripepo.
Thank you. Thank you.
Yes.
Just to clarify where I left off, I had said that the Court of Appeal declared the provisions of the AJ as void, and have that being debated. Please refer to page 23 of the judgment. I have a CTC, and then you find that there. And I think that's settled. Please, very quickly, I'd like to just touch on some things Dr. Lawanyi has said, and that, and I understand and I agree with him. But I think that the issue here is not really the point that Dr. Lawanyi makes so very well is about the desirability, of another outcome, rather than the correctness of the outcome of the Court of Appeal. And I think there are two different things. In terms of desirability, perhaps I agree with him, even though I shouldn't be saying that here because of my own position. Now, in terms of the principles of interpretation of the Constitution, the Lawanyi had said he had thought the Court of Appeal will then do an exposition of that. I think it's very important that I emphasize that we operate an adversarial system of justice here. And so I do not really see the Court of Appeal going beyond the scope of the appeal before it and going into matters that are extraneous. If they had done that, I see the Supreme Court setting aside the judgment on that alone. And I'll very quickly say, and I understand the point made in Rabiu, Elelu, Abib, Skybank, and Iwa, and all of that, but I refer to a recent decision of the Supreme Court, Attorney General of Cross River State and FRN, which I think is the relevant authority here. And I should read that because of what Dr. Lawanyi said about there's no principle saying this. And this is what the Court of Appeal said, the Supreme Court said. It said, when the provisions of the Constitution and of the statute are clear and free from ambiguity, they should be given their plain meaning without any embellishments. Interestingly, the Supreme Court here was interpreting a jurisdictional provision, the provisions of Section 232 of the Constitution. And I think the law is clear on that the courts cannot expound. They can expound, but they can't expand their jurisdiction. So my question really is, if we look at the issues joined by parties, I don't think there was any issue of ambiguity. And so it was needless for the Court of Appeal to have gone on the voyage of trying to determine the purpose of the Constitution. That said, I'll say this also very quickly. I also understand the point, again, on the desirability of securing the claim. If we go on that part, my question will be, where do we stop? And I understand Dr. Lawanyi's sentiments. And I'll mention another point on which I know Dr. Lawanyi will take on a very sentimental note. Now, I heard, not from Dr. Lawanyi, but from the reviewer saying that maritime claims are sacred and sacrosanct. I'm not sure there's any constitutional basis for that. But I'll ask the question, what makes a maritime claim more sacrosanct than a claim under Section 251, subsection 1E? So, for example, if a director of a company sues for his remuneration, right, before the introduction of Section 254, subsection C, it would have been a matter for the Federal High Court. The Federal High Court, over the years, has developed what I'll call expertise in determining such matters. I don't think it will go to the Federal High Court now, certainly. Now, someone else could argue, especially the person is a company law lawyer, which Dr. Lawanyi is, that, oh, I think that we should leave this at the Federal High Court. And then by the time we start to take that one by one, we go to aviation, we take it off, we go to this, is sacrosanct. Then question is, what was the purpose the draftsman had in mind when introducing Section 254, subsection C. I want to believe that the purpose was to introduce some form of specialist court to deal with these matters. And I'll tell you something. In some purpose, we had the matter where the claim was for $55,000, and then a vessel was arrested for 3 years, or if not going to 3.5 years. Now, the scrap value of the vessel is worth 70 times the value of the claim. And so you're saying now that because there are two sides to this sentiment, that you want to use a vessel that is worth 70 times the size of the claim to secure, a claim of $55,000. Now, we need to look at our peculiarities in Nigeria. Of course, the delay in the administration of justice. And we all know, I've only been to the National Industrial Court a few times, but I think I wouldn't be stating the counterfactually if I say that proceedings at the National Industrial Court are faster than we have at the Federal High Court. Again, I'd leave it there, but I just wanted to say something as well in terms of constitutional interpretation. And when looking at the AJA, juxtaposing it with the provision of the Constitution, there's an interesting perspective to the doctrine of covering the field, which the Supreme Court laid down in Attorney General of Abia and Attorney General of the Federation. And Supreme Court appear to be saying that once the Constitution has made provisions for a particular matter, then for an act of the National Assembly to repeat it alone, not to talk of clarifying it or embellishing it or expounding it, is unconstitutional. That once the Constitution has laid down the position on the matter, then that suffices. Any other thing will be unconstitutional. Which is what I think has happened here, really. In the final analysis, I think what we're going to be needing will be a constitutional amendment rather than judicial clarification. In terms of concurrence of jurisdiction, we had NDIS and Okem Enterprises, where the Supreme Court then resolved the issue in terms of the jurisdictional tussle between the Federal High Court and the State High Court, and came to the conclusion that there should be concurrence of jurisdiction. Well, that was years ago. It's still not settled. I think I've written on that a few times. It's still not settled. And the matter has now been further compounded in the new warfare, where we have a new tribunal instituted. And as I was reading it, I was thinking, okay, where does this tribunal come in now? Because you now have Federal High Court, State High Court, and then you have the tribunal. So the debate continues. I think the best way is for us to have an amendment, and then the National Assembly can make it very clear. Of course, stakeholders will be heard since it's a constitutional amendment. Make it very clear what really the intention is. But for now, based on the wordings of the Constitution, I don't think anybody requires anything clearer than using the words any repeatedly, using the words notwithstanding anything in sections 251 of the Constitution. I don't think there's any debate, and that definitely did not come up, and it wasn't necessary for the Court of Appeal to go down that route. Thank you.
Mr. Kuti, sorry, yeah.
Yes.
Mr. Kuti.
Yes, please go ahead.
Okay, I just wanted to make this short point. The clarification is that it is not maritime claim that I said enjoys a sacrosanct or sacred nature. It is maritime liens. If you look at the AJA, maritime claims are divided into two. We have proprietary maritime claims relating to ownership or shares in a vessel, and then general maritime claim under where you have, claims for crew wages. And they single out crew wages and damage done by a vessel, salvage, by their nature. Traditionally, from time immemorial, because maritime law is international, let's also not forget that. Now, whenever we talk about maritime jurisdiction, it is not a nationalistic law. So I want to clarify that it is not maritime claims that I say are sacrosanct. It is maritime claims which gives you right that inures to the vessel and attaches with it until it is extinguished.
Fantastic.
Get that point clear.
Fantastic. Yeah. Thanks, Noso, for the additional clarification. Context has been added. Dr. Oladekweku, I must say that was a brilliant rebuttal. It's almost difficult to know where it swings or to determine where it swings. I mean, virtually everything you say, strong point. I think the only thing I may probably not just take in completely would be the issue of covering the field. My understanding is that, yes, you could cover the field, but some other statute can now make provision for it as long as it is complementing. It is when it departs from the wording of the general statute, or it's not even the Constitution. That's when you say, oh, it's covered the field, and as such, this is constitutional. And maybe that is the reason why, for example, you have provision relating to evidence in rules of courts, whereas evidence is ordered exclusively legislatively. But I mean, all said, in all, I think it's equally very important to point out that the purposive interpretation that we're seeking of here is that when you look at the literal interpretation of the Constitution, and it will lead to absurdity. What is the absurdity here? The absurdity that is identified is that the Constitution that says it can or it should be everything from the interpretation, literal interpretation, there's no doubt. Every labor matter, labor and employment, irrespective of where the worker is, should be an industrial court. But when you have conflicting or competing with other laws, which in any event are laws, existing laws within the intent of 315 of the Constitution in itself, and the interpretation, sticking to that literal interpretation, will probably lead to some sort of absurd, or will produce some absurd result interpreted alongside with other laws. Then that is when a purposive interpretation is called for. But again, the arguments can go on and on and on. Mr. Gbenga Bello, please, you have the floor now. Can you kindly unmute yourself and let's have your perspective?
Thank you very much, Falabi. My Lord Justice Kadib, it's good to have you again. Learned Senior Advocate, thank you very much for your incisive comments. On behalf of Elan, which I'm proud to belong, I want to say a very, very big thank you for sharing your time to join us in a topic that we had debated on our group before now. And I don't think I have changed. I mean, having listened to the brilliant submissions of both senior advocates, it just confirms my own, my own belief that the intent was never to excavate the Admiralty jurisdiction of the Federal High Court to the NIC in respect of this specific type of claims. And for me, I think my worry is the fact that while we as lawyers are theorizing and we are speaking so much grammar, there is a state of flux apparently caused by this judgment. And we have seamen whose claims are accruing daily against ships, plying the waters of Nigeria. If today they need to go to a court, and remember, as Nonso correctly has said, that the essence of the lien created in favor of a maritime worker is to be able to arrest that ship, to secure payment in the event that he gets a favorable judgment. Assuming that such a claim has to go to the National Industrial Court as at today, so that we avoid what had happened in the case of CBN and Obi, where people went on a tirade of 25 years. And what happened was they had to come all the way back to start a trial de novo because of the magical jurisdictional issue, which is created by laws made by we lawyers, or by interpreted by we lawyers. And we find that we just put people in a situation where they will wait, their claims become almost obliterated because we are theorizing. Is the NIC today equipped with the powers to arrest a ship in view of its generic powers to seize property? I know that, I'm not a maritime lawyer, I know that maritime, to enforce these maritime claims, or in fact, the process of bringing them to court requires strict rules that you must comply with strictly. What are those mechanisms in the NIC that gives you that basis to enforce this kind of maritime claims as it is today, without the workers being at the risk of a Supreme Court 4, 5, 6 years down the line saying that, look, go back to the Federal High Court that is properly constituted with the rules and with the wherewithal to arrest the ship? Thank you very much.
Interesting perspective. and then still with a poser. Unfortunately, I'm not sure we have all the time. And some aspects of what Benga has shared now, I think, has been addressed. But again, it's a continuing debate. It's a continuing debate. In the meantime, I mean, just to let everybody know, there's a poll that we've asked participants to kindly be part of. Just indicates, do you agree that the decision was correct? Yes, no, undecided. I mean, Elan, quite apart from having talking points of this nature, I mean, the Elan is actually looking at taking a bit forward, taking a step further to see how you can bring about change. I mean, the desired change that we actually want in both the law and its application and enforcement, and the jurisprudence driving the justice delivery system. So kindly indicate what your position is in the poll. I doubt if we have time for the questions, but like we said, this is just this is a start. It's not anything we can end today. Thankfully, the Supreme Court's door is open, and I can imagine that Dr. Lanikwekun will let us know when the notice of appeal is deposited. And I think it would be good for the Supreme Court to actually take it beyond what it is now. It is one that should attract, at the very least, should attract the invitation of amicus to come and examine the various issues, as opposed to what happened in Skyback and Ewo. So thank you very much. And I think at this point, I would invite Mr. Jamiu Akolade, one of the trustees, to come and give the vote of thanks. My Lord, I thank my lords for being in attendance. Dr. Olawanyi, Dr. Lanikwekun, also the maritime lawyer, so that you can have time to go arrest the next ship. All that. Thank you very much for having everyone. Jamiu, please, it's over to you. Yeah.
Thank you, my lords and the senior advocate.
Okay. So you're okay. Jamiu, please go ahead. You're done?
Jamiu, you're muted.
Okay. Oh, I'm sorry about that. I'm so sorry. Good evening, everyone. My name is Jamiu Akolade. I'm one of the trustees of the Employment and Labor Lawyers Association of Nigeria. We could not be more glad than we are this evening to have the caliber of persons that we have in this month's case review. I stand on existing protocol to say good evening to my Lord Justice B.B. Kanyip, the President of the National Industrial Court of Nigeria, Honorable Justice Afen, JCA in waiting. I say good evening and thank you too for attending this event. So many notable labor law practitioners I can see on the participants list. Mr. Bimbo Atilola, even though you didn't get to say something, but we could see all your thoughts in the chat box. Thank you for coming. Mr. Adeafun, I think I saw. Mr. Ose Oseku, the chairman of the MBA SBL Employment and Industrial Relations Committee. Thank you. All the members of ELAN who have continued the debate even while the session was going on in the group, in the chat group. I say thank you all for throwing up this topical issue. As we can see, we are undecided throughout the debate. I started on firmly on the side of the position of, I went back to the group and said, doctors really changing minds. And then Dr. Lanikwekun spoke again, and then I switched back to my position, of course, with the assistance of the firm convictions of my Lord Justice Kanye. That tells us that there are no easy answers to these issues, and this can only be the beginning of the conversation, like Mr. Kuti mentioned. I want to thank you for spending over 2 hours, about 2.5 hours now, with us this evening. And we hope that you will join us in further case reviews and further events of the association. You can visit our website, www.elan.com.ng, where you will find all the information you need about the association, membership, past videos of past webinars, past publications, and basically all you need to know about this association. We are quite committed to contributing meaningfully to the development of labor and employment law in Nigeria. On that note, I will say thank you for coming. Before I go, I'll just announce the results of the poll. 20% agree that the decision of the Court of Appeal in this case was correct. An overwhelming 56.7% disagree with that decision, while a quite substantial amount of 23.3% are still undecided. And that tells you how dicey this issue is. Maybe for a compromise, we might go on the moderate advocated by Dr. Lawon SAN. But then we hope that with the caliber of the leaders in the sphere that we have on this call, that they will take all this feedback to the boardroom, so to speak, and then we can chart a better way forward on this issue amongst others. Thank you very much all for joining.
Thank you again. Thank you all. Happy to, I didn't know Bimbo. I could see Bimbo's handiwork in the chat room. Understandably, the position will be that everything should be at the industrial court. Thank you. Have a good evening, everyone. Thank you.
Thank you very much, Mr. Kuti, for a wonderful presentation. Yeah.
Thank you, sir.
Thank you all. See you
Thank
next
you, everyone.
month.
Bye.
Thank you, my Lord Kanyu, for your time. Jamie, cheers. Bye.
You're welcome.
Thank you, my Lord. It's a pleasure to have you.
Thank you.
Who's here?